Dear friends and colleagues, chers amis et chers collègues, first of all, I would like to thank the team of the center and mostly its director, Werner Gebhardt, for the invitation to participate in this final conference. I cannot begin without expressing the impact that the center has had in my career as a young legal scholar and a researcher. This is a wonderful place. The center is a wonderful place to think and to share different ways to do research about law and culture. So I make the wish, really strong, that this final conference will be the beginning of new foundations to continue to build a strong scientific community together. So today, I'm honored to have the beautiful mission to share this second panel, Applying the Law as Culture Paradigm. I'm also mostly honored and happy to introduce the presentation of three great colleagues. And I have to confess my admiration, like a rock groupie, to the work of these three colleagues, Raya Sakrani, Martin Albro, and Greta Olson. They will illustrate the fecundity of the law as culture paradigm. I can also tell you that they will show us a world of possibilities, le monde des possibles, of the intersection proposed by the law as culture paradigm as such law, culture, and society in a plural way. Raya Sakrani, Dr. Raya Sakrani is a jurist and cultural science scholar. Since 2010, she has been a scientific coordinator at the Käte Hamburger Center for Advanced Study Law as Culture. To present Raya and her work, I could use the following phrase: le monde c'est l'autre. The world is the other. Her work reflects the generosity to see the other in all its complexity. Her current research focuses on the reciprocal presence of Islamic tradition in Europe, enlarging the view of how the other is treated in a complicated normative situation. Through her engagement at the center, she offers us a considerable scientific production on law and culture through the comparative perspective on the basis of the Islamic cultures and religions. Some examples of this could be her participation as co-director of the international and interdisciplinary research project Convivencia with the Max Planck Institute for European Legal History in Frankfurt, and also the teaching experience at the universities of Paris, Bonn, Basel, and Madrid. We know how difficult these comparative perspectives could be, and her work can show us the multiple ways to articulate this. So we can look forward to her forthcoming book, Image of the Other in Islam. Is there an Islamic mimetism? Raya will present in French his stock. The title has been a little bit modification, Les révolutions arabes, échec d'un projet normatif. The Arabic Revolution, a failure normative project. I don't know if I present all the authors, and after that I can give you the time to speak. I would also present Professor Martin Albro. He is an eminent and one of the first globalization theorists of one of the most renowned English language experts on Max Weber writing. His interest in Max Weber work begins at his early age and through the heritage of his father, who has a close contact with German culture. Professor Martin Albro studied history and sociology at the London School of Economics, as well as the University of Cambridge, where he obtained his doctorate degree in 1971. Since 1988, he has held many guest professorships and fellowships in Europe and the United States, including at the London School of Economics, the University of Munich, the State University of New York, as well as the Woodrow Wilson International Center for Scholars in Washington, D.C. Professor Martin Albro is honorary vice president of the British Sociological Association and member of the International Future Forum. From October 2012 until September 2013, Martin Albro has fellow at the Käte Hamburger Center, where he has conducted research on the topic of globalization, multiculturalism, and principle of global governance. Since October 2013, Professor Albro is senior fellow at the center, and he will delight us with the presentation, integrity, cultural, and the law. And the third presentation will be due by Professor Greta Olson. She's a member of the Center's Scientific Advisory Board of the and professor of English and American Literature and Cultural Studies at the University of Gießen. As Martha Bullock presented her this morning, Professor Olson works in the areas of cultural and narrative approach to law, critical American studies, media and feminism, and sexuality studies. Her recent publication will be Beyond Gender, Futures of Feminist and Sexuality Studies. And she will share with us the talk From Legal Culture to Legal of Legality. So I can let Raya Sakrani begins with his presentation.
Thank you very much, Diana, for your kind presentation. And yeah, I would like to start by the following. Ladies and gentlemen, good afternoon. I'm really glad to be here and to see friendly and familiar faces. As I was asked to give my paper in French, I will now switch to French. So, les révolutions arabes, échec d'un projet normatif, voilà la question à laquelle je vais tenter de répondre pendant les prochaines minutes. Les années récentes ont ébranlé les perceptions approximatives et les idées toutes faites. Le monde arabe, qu'on dépeignait comme résigné face à l'ordre autoritaire, donnait même le ton des orientations révolutionnaires d'un 21e siècle qui s'installait. Ce qu'on a appelé printemps arabe, amorcé en Tunisie dès décembre 2010, s'imposait comme le premier prototype de ces révolutions postmodernes, numériques, substituant les réseaux sociaux à la discipline de fer de l'organisation révolutionnaire léniniste. Plus encore, le mouvement se propagea très vite dans ce contexte nouveau, en Égypte, en Libye, en Syrie, à Bahreïn, au Yémen, notamment, mais aussi à l'extérieur, en Espagne, où il a inspiré les Indignados, puis dans l'ensemble de l'Europe et jusqu'aux États-Unis, où il a fortement inspiré le mouvement Occupy Wall Street. La thématique forgée de l'immolation du jeune marchand ambulant Mohamed Bouazizi n'a-t-elle pas amorcé ce temps nouveau des grandes mobilisations de sensibilité révolutionnaire en installant l'idée de karama, c'est-à-dire dignité, au centre même des revendications émises? On trouvera en effet le mot et sa force mobilisatrice peu de temps après, en France avec le mouvement des Gilets jaunes, mais également dans les cortèges qui ont jalonné l'année 2019 de Santiago du Chili à Port-au-Prince, de Hong Kong à Beyrouth. L'évocation de cette dernière étape révèle même la résilience régionale du modèle. L'année 2011 trouve ainsi sa réplique géographique dans l'année 2019, touchant cette fois le Liban, mais aussi le Soudan, l'Algérie, avec le Hirak, mot qui signifie en arabe mouvement ou mobilisation. En Irak aussi, et débordant même sur l'Iran. Ne tombons pas dans l'excès non plus. Certes, chaque épisode révolutionnaire ou simplement émeutier a bien sûr sa particularité, hérité d'une histoire longue et d'un contexte propre. Mais ces nouveaux référentiels, nés sur les rivages de la Méditerranée orientale, sont bel et bien insérés dans une mondialisation au sein de laquelle le monde arabe ne tient plus un rôle marginal. Celui-ci participe activement de cette manière à la réinvention d'un monde à bout de souffle où se mêlent plusieurs agonies, celle des vieilles hégémonies, celle d'un néolibéralisme naïvement triomphant, celle d'un autoritarisme personnalisé et celle enfin d'un uniforme culturel désuet. Or, s'il est légitime de parler d'une expérience arabe de la Révolution ou même de circonstances qui ont été propices à l'éclosion de ces expériences, il serait malvenu de parler d'un modèle révolutionnaire arabe. Pour tenter d'expliquer cela, je vais essayer de traiter ces questions en deux parties. Premièrement, complexité et ambiguïté du référentiel normatif révolutionnaire, et puis je passerai au problème des révolutions sans leader et les leaders des changements normatifs entre polarisation et compromis. Donc, la complexité du référentiel révolutionnaire d'abord. L'histoire, comme vous le savez tous et toutes, est faite d'emprunts, de contacts, de diffusion, mais aussi de circonstances et de conjonctures. Au titre des premiers, le monde arabe a observé et subi indirectement ou non, les effets de la Révolution française, un peu dans l'immédiateté, beaucoup par lente propagation des idées qui en ont dérivé. Celles-ci ont touché plusieurs mouvements de pensée, mais tout particulièrement ce qu'on appelle en arabe la nahda à la fin du 19e siècle, qui veut dire littéralement renaissance. Ainsi, la Révolution française de 1789 a nourri abondamment le nationalisme arabe qui s'est épanoui par la suite, notamment sous l'égide du président égyptien Jamal Abdel Nasser. La révolution russe de 1917 a marqué d'une autre manière tout un courant socialiste étatique que le jeu bipolaire de l'anti-occidentalisme ambiant avait contribué à populariser dans cette région après la fin de la Deuxième Guerre mondiale en 1945. Ces orientations politiques et idéologiques, ou plutôt ce qui en reste après les soulèvements de 2011, se verront confrontés en pleine bataille populaire et électorale pour déterminer les choix politiques et les réformes normatives à adopter. Ces diffusions inspirées des élans révolutionnaires européens et soviétiques seront activées par le rôle croissant des diasporas qui recueillent les traditions au dehors, essentiellement en Europe, pour ensuite les recomposer à l'intérieur. Voici en gros pour les emprunts et les contacts. Quant aux circonstances propres au monde arabe, une caractéristique particulière doit être soulignée. Si on se limite au temps contemporain, le joug impérial ottoman et surtout la domination coloniale française et anglaise notamment créait évidemment des circonstances favorables aux mobilisations révolutionnaires orientées dans un sens clairement nationaliste ou pré-nationaliste, liant même de façon intime pour un long moment les idées de nation et de révolution. Par la suite, la séquence autoritaire qui a marqué l'histoire des régimes politiques arabes a élargi l'idée d'émancipation collective et de dignité des peuples soumis à celle de la conquête de droits individuels. Les revendications pour la personne rejoignaient aussi celles concernant la communauté. Cette oscillation quasi permanente entre individus et communauté. Et je dois dire qu'ici, quand je parle de communauté, je ne parle pas du communauté au sens de Oma, ce que j'ai développé l'année dernière dans notre colloque sur la Gemeinschaft, un colloque sur les communautés. Donc, cette oscillation souvent antagoniste entre individualisme et communauté détermine dans une large mesure l'échec du projet normatif censé déboucher sur la réalisation des objectifs démocratiques. Deux orientations s'insèrent ainsi parfaitement dans une histoire et une sociologie comparée des révolutions. Premièrement, le monde arabe dispose de tout un référentiel culturel qui lui permet d'agir dans une continuité de pensée. Le récit islamique nous introduit ainsi à un référentiel riche, mais extrêmement complexe, ambigu, voire paradoxal, d'un héritage religieux qui tient en otage tous les champs normatifs de la société, y compris la sphère juridique. Deuxièmement, le récit communautaire, en particulier la sociologie chaldonienne, introduit de même à la nécessaire régénérescence des formes d'intégration sociale et au rôle de ceux qui en prennent l'initiative. L'obstacle majeur, donc, à la base est d'ordre socio-culturel. La réinterprétation différenciée de ces traditions diversifie les modèles révolutionnaires qui ont pu inspirer les acteurs sociaux. Rappelons les traditions kharijites et surtout chiites, puis wahhabites, salafistes qui se sont propagées dans tout le monde arabe et qui ont pu ainsi imposer leur voix propre et susciter des traditions bientôt antagonistes les unes des autres. La révolution tunisienne n'a pas été menée par les islamistes qui ont surgi dans les rues à peine 2 jours avant que Ben Ali ne quitte à jamais le pays. Et donc, vous voyez déjà, il s'agit d'un paradoxe apparent de la révolution tunisienne, mais aussi d'autres modes révolutionnaires dans le monde arabe. Et pourtant, les islamistes, ils avaient réussi à être majoritaires au Parlement et à mener les gouvernements successifs jusqu'au 25 juillet 2021. En Égypte, le poids politique et surtout populaire des frères musulmans est lourd, mais leur accès au pouvoir a échoué à instaurer un régime démocratique et à dépasser les valeurs discriminatoires d'un islam rétrograde à l'égard des femmes et des minorités. Aujourd'hui, c'est de nouveau l'armée qui tient les rênes du pouvoir avec la main de fer de Abdel Fattah al-Sisi. De ces deux exemples, on voit combien la révolution est au centre même de l'histoire et de l'imaginaire propre au monde arabe, tant comme composante de la pensée premièrement et comme vecteur d'action deuxièmement. La première, c'est-à-dire comme composante de pensée, s'est construite dans un rapport à l'autre, extérieur, fait d'emprunt, de fascination parfois et de rejet aussi. La deuxième, c'est-à-dire comme vecteur d'action, réside dans la mondialisation qui a fait de celui-ci un champ tout à fait privilégié, marqué par une exceptionnelle densité événementielle et de transformation radicale, parfois d'une violence extrême. Comme foyer de guerre, bien évidemment, nous savons tous, je peux mentionner la Syrie, la Libye, l'Irak, le Yémen. Comme espace de contestation de régime dont la légitimité est incertaine, nous avons l'Algérie, le Liban, la péninsule arabique, l'Égypte, le Soudan, comme support remarquable d'intervention étrangère à travers les guerres aussi, c'est-à-dire l'intervention de l'Europe, des États-Unis, de la Russie, de la Turquie. Nous avons notamment le cas de la Syrie, de la Libye, l'Irak, le Liban, etc. De plus, comme enjeu de compétition culturelle et religieuse, ce monde gagne de plus en plus en centralité parmi les processus révolutionnaires mondiaux. Je passe à la deuxième partie, révolution sans leader et les leaders des changements normatifs entre polarisation et compromis. Je cite, « Notre révolution, c'est comme Wikipédia. Tout le monde contribue et les contributeurs sont anonymes. Tout un chacun y met sa touche. Tous ensemble, nous réalisons la photo de la révolution. Et sur cette photo, il n'y a pas de héros. » Fin de citation. C'est ainsi que s'exprimait Wael Ronim dans l'interview avec la journaliste Nancy Scola, intitulée « Our Revolution is like Wikipedia », le 14 février 2011. Pour l'histoire, ce jeune Égyptien responsable marketing chez Google à Dubaï a joué un rôle clé dans la révolution égyptienne, notamment après sa captivité et détention secrète pendant 12 jours avant la chute de Hosni Moubarak. À l'instar de Wael Ronim, en Égypte, en Tunisie et ailleurs, les révolutionnaires de 2011 ne se sont pas contentés de faire la révolution. Elle et il l'ont raconté de mille et une façons, proclamant souvent, mais pas toujours, nous sommes tous des leaders. Donc, vous voyez le paradoxe, nous sommes tous les leaders et en même temps, en fait, il n'y a pas eu de leader au sein de ces révolutionnaires jeunes notamment. À travers des récits concurrentiels, elle et il ont produit le sens de leur action en diffusant une vision unifiée de collectif hétérogène. Et voilà un autre problème qui a mené à l'échec normatif qui s'est traduit par la suite à travers les textes juridiques, constitutions notamment et autres. Elles et ils ont célébré des valeurs, l'absence de leader et le porte-parole, l'approche participative, l'horizontalité, qui s'opposent à la culture politique traditionnelle fondée sur la valorisation du leadership, le culte de la personne, du raïs ou de zaïm, comme on dit en arabe, en Tunisie, en Égypte et ailleurs, de la centralisation et de la hiérarchie. Reste à souligner que les scripts révolutionnaires changent d'une séquence à l'autre et que la révolution Wikipédia a cédé la place à d'autres images. Peu à peu, les divergences internes sont rendues publiques et la voix des urnes, le cas de la Tunisie et l'Égypte notamment, lorsqu'elle n'est pas étouffée par la répression ou supplantée par le déferlement des armes, le cas de la Syrie, la Libye et le Yémen. Le sentiment de dépossession gagne alors les acteurs réels de la révolution. L'expression arabe « rukoub ala thawra » qui veut dire littéralement monter sur la révolution ou voler la révolution, répand son goût amer dans les bouches des désillusionnés. A posteriori, cette perception a nourri les regrets de certains militants et chercheurs. Les icônes des révolutions de 2011 ne disposaient pas des ressources organisationnelles qui auraient permis l'avènement d'un nouvel ordre social et politique conforme aux images enchantées des agoras où la révolution se réinventait au quotidien. En revanche, les islamistes dotés depuis de longues années par de structures organisationnelles solides et des ressources financières immenses, le pétrodollar notamment, n'ont pas manqué de déferler sur la Tunisie ou l'Égypte d'avant-Sisi, soutenant le parti d'An-Nahda ou Al-Ikhwan en Égypte dans les campagnes électoraux et l'instauration de tout un système non seulement politique mais aussi juridique, administratif et sociétal permettant la réalisation du projet islamiste voire salafiste. Ceci dit, les soulèvements modifèrent la signification du public dans l'imaginaire collectif rompant avec la domination des formes oppressives que les États-nations modernes avaient prises dans le monde arabe. Et ceci est plutôt positif. Donc, si la place Tahrir a été inventée, d'autres espaces ont été réappropriés. Par exemple, les rues et places de Tunis, jusqu'alors au cœur de l'appareil d'État autoritaire et répressif. Le grand gain de la révolution tunisienne jusqu'alors est justement la liberté d'expression et la réappropriation de l'espace public. Au-delà du moment révolutionnaire, des espaces publics centraux tels que la Médina, l'avenue Habib Bourguiba ou la place de Kasba demeurèrent les lieux où des citoyens organisés par eux-mêmes inventaient une gamme d'actions civiques et politiques nouvelles. De la même manière, le soulèvement d'octobre 2019 mena dans les villes libanaises à des moments de réappropriation de places et de bâtiments publics par le moyen de drapeaux colorés, graffitis, performances de rue, qui servirent aussi de cadre à des lectures ouvertes, des soupes populaires ou des séances même de psychiatrie. En fait, les révolutionnaires arabes considéraient l'espace public comme un bien volé devant être recouvré. Parallèlement, et ça aussi c'est positif, la révolution des LGBTQ arabes est toujours en cours, même si le dispositif normatif tarde à l'accompagner. La Tunisie reste le seul pays qui a échappé, malgré les épisodes de violence et de terrorisme, au scénario de la guerre civile comme en Libye, en Syrie et au Yémen, ou de coups d'État militaires tels que le cas de l'Égypte et récemment le Soudan. Je vais donner quelques exemples pour terminer, quelques exemples concrets de la Tunisie pour vous montrer aussi les manifestations, malheureusement, de l'échec normatif. Des études indépendantes publiées entre 2020 et 2022 démontrent l'ampleur dramatique d'un phénomène qui constitue l'un des grands problèmes ravageant le pays. Et pourtant, ce problème était l'une des causes de la révolution. Il s'agit de la corruption. Les défaillances commencent par l'échec dans la mise en place d'un dispositif normatif cohérent et efficace permettant la lutte contre ce type de comportement criminel. Depuis 2011, l'oscillation entre la polarisation idéologique et religieuse, allant jusqu'à la menace terroriste d'une part, et les compromis politiques entre les différents acteurs et partis politiques d'autre part, ont débouché sur un patchwork de textes juridiques et de lois inefficaces, voire contradictoires, à commencer par la Constitution elle-même. Celle-ci, rédigée, je vous rappelle, en 2014, dans une atmosphère politique et sociale très tendue, voire sanguinaire, souffre de contradictions dans les choix politiques, imprécisions, voire de médiocrité dans plusieurs de ses aspects techniques et langage juridique, constitue encore aujourd'hui, donc cette constitution constitue encore aujourd'hui un obstacle à la mise en place d'un régime politique clair et d'un gouvernement stable garantissant le bon fonctionnement des différentes institutions étatiques. Le parti islamiste Al-Nahda, avec sa majorité parlementaire, a tout fait pour écrire une constitution sur mesure qui lui assure une pérennité au pouvoir et la monopolisation du pouvoir législatif, notamment à travers sa majorité parlementaire. En matière de valeurs démocratiques et citoyennes, on a échappé à peine à un retour en arrière privant les femmes de leurs droits civils et politiques. Ennahda avait fait scandale durant l'été 2012, rappelez-vous, en annonçant vouloir introduire le concept de complémentarité homme-femme, donc pour éliminer le principe de l'égalité entre les hommes et les femmes. Le parti a finalement renoncé à ce projet. Et heureusement, la version finale n'a pas consacré le principe cher aux islamistes, celui de la non-égalité entre les hommes et les femmes, malgré une rédaction mauvaise et hésitante de l'article 21 qui est très long, je ne vais pas le citer. Les islamistes ont aussi accepté au fil des mois de renoncer à inscrire l'islam comme source de droit. Et heureusement, la Tunisie échappe encore à ce principe constitutionnel qu'on trouve déjà en Égypte, qu'on trouve dans beaucoup d'autres, en Syrie, dans beaucoup d'autres pays qui ont vécu les révolutions. Et aussi la règle de punir les atteintes au sacré. Et ça aussi, c'était nouveau, c'est post-révolutionnaire, c'est même pas avant la révolution. Ils ont aussi accepté sous la pression de l'opposition laïque l'interdiction des accusations d'apostasie. Ça était programmé pour la Constitution. Donc, au moins, ce qui est positif, on a pu échapper à cela. Quant à la liberté de conscience, la lutte de la société civile et des activistes des droits de l'homme a réussi enfin à instaurer le fameux article 6, une première dans le monde arabe, malgré l'ambiguïté de sa rédaction. Je cite un paragraphe, « L'État est gardien de la religion, il garantit la liberté de croyance, de conscience et le libre exercice des cultes. Il est le garant de la neutralité des mosquées, lieux de culte, etc. » Ça continue et ça pose évidemment de problèmes parce que ça relativise énormément ce principe de la liberté de croyance ou de conscience. Une percée, certes, mais l'islam reste la religion de l'État, comme l'énonce l'article 1er qui interdit de surcroît l'amendement de ce texte, ce qui laisse la porte ouverte à l'intervention étatique ou d'une justice conservatrice, comme je vais mentionner tout à l'heure. Quid de la justice, des juges, surtout après l'échec phénoménal de la justice transitionnelle. Après plus de 11 ans depuis la Révolution, le constat est sans appel. Malgré les élections et les gouvernements successifs, toutes tendances confondues, il n'y a pas eu une volonté réelle pour garantir aux juges un statut juridique leur garantissant l'indépendance et la neutralité. Tout commence par la Constitution elle-même, qui ne consacre pas l'indépendance réelle et effective du corps judiciaire. Ici, je voudrais bien faire juste une petite remarque. Ici, je parle des juges et non pas des avocats. Les avocats en Tunisie est un corps à part. Ils étaient très actifs pendant la Révolution et ils sont très impliqués dans la politique. C'est la raison pour laquelle dans les anciens gouvernements, on trouve beaucoup d'avocats parlementaires, députés qui siègent au Parlement. Et donc, quand on parle du corps judiciaire, il faut absolument faire la différence, mais ça mérite une autre conférence. Je voulais juste le mentionner. Je me concentre donc sur les juges. Une réforme efficace et durable pour assurer l'indépendance des juges et de la justice doit passer donc obligatoirement par la Constitution, mais aussi par la réforme de la loi du 14 juillet 1967. Imaginez, la loi fondamentale qui régit le statut des juges date de 1967, qui a été bien sûr modifié à plusieurs reprises, mais le corps de la loi reste inchangé. Et donc, malgré ces réformes partielles, le corps, comme je disais, reste inchangé. Et pour résumer la complexité, je vais insister sur 3 points qui tournent autour d'une problématique centrale, la dépendance à l'égard du ministère de la Justice. Premièrement, le ministère public dépend du ministre de la Justice. Donc, il n'y a pas une indépendance du ministère public. Celui-ci est purement et simplement le président du ministère public, c'est-à-dire qu'il dispose du pouvoir lui permettant l'ouverture d'une enquête judiciaire, la mise en inculpation, l'orientation des recherches et même d'arrêter ou de clore les enquêtes. On comprend pourquoi, dans les 2 grandes affaires d'assassinat politique de l'avocat Chokri Belaïd et du député Mohamed Brahmi, les assassins depuis 2013 n'ont jamais été arrêtés et jugés. De plus, le ministre de la Justice a le pouvoir de questionner les juges, de les inculper et de déclencher une procédure disciplinaire à leur égard. De ce système normatif pervers, et là c'est très intéressant, une culture juridique étrange c'est assez bien installé chez beaucoup de procureurs de la République. C'est eux-mêmes qui prennent l'initiative d'impliquer le ministre de la Justice en lui demandant des ordres ou des suggestions dans les grandes affaires, notamment à dimension sécuritaire, politique ou économique impliquant la corruption. Donc, ce sont les procureurs qui exercent sorte d'auto-censure ou une référence au ministre pour l'impliquer dans la procédure, ce qui contre, bien sûr, l'indépendance. Deuxièmement, l'inspection générale de la magistrature dépend également du ministre de la Justice. Troisièmement et enfin, c'est le président de la République qui désigne les membres du Conseil supérieur de la magistrature, car selon la loi que je viens de mentionner, c'est lui-même qui occupe le poste de la présidence au sein de ce conseil. Son ministre de la Justice occupe le poste du vice-président. Donc, vous voyez vraiment, et la boucle est bouclée pour les juges, c'est le président de la République, président, et puis son ministre vice-président. C'est dire à quel point cette dépendance est ancrée dans la culture juridique à la fois du corps judiciaire et du pouvoir politique. Le président actuel, Kais Saied, vient de rater lui aussi la chance d'un véritable changement qui touche à la culture normative la plus fondamentale, celle de l'indépendance des juges. Car si la raison d'être de sa dissolution de l'ancien Conseil supérieur de la magistrature est compréhensible, je vous rappelle, la dissolution a eu lieu le 10 février dernier, 10 février 2022, la nomination de ses membres par le même Saïd ne rend pas service ni à l'indépendance des juges, ni au processus démocratique. Aussi, il ne faut pas oublier que l'indépendance des juges ne doit pas être analysée d'un seul point de vue, du point de vue seulement juridique. Il existe des raisons extra-juridiques qui relèvent d'une nouvelle culture post-révolutionnaire. Les juges sont de plus en plus la cible de la pression exercée par les médias et la rue. L'organisation des manifestations devant les tribunaux, par exemple, quelque chose qui était impensable avant la Révolution, ou la menace des juges, ou encore la menace des juges qui est devenue presque une chose anodine. Finalement, il convient de rappeler que certains juges, même s'ils ne sont pas majoritaires, ne croient pas à l'indépendance de la justice. Ils sont plutôt les adeptes d'une culture juridique qui fait de la justice et du pouvoir politique deux sphères interdépendantes, car beaucoup d'entre eux rêvent de décrocher un jour le poste d'un ministre ou même d'un maire, un burgermeister. Donc, vous voyez, ça vient aussi des juges, bien sûr, une partie minoritaire, mais ça vient des juges eux-mêmes, cette culture de la dépendance à l'égard du pouvoir politique. Je vais terminer rapidement. Encore en mentionnant quelques points positifs, il y a eu des acquis post-révolutionnaires positifs car les juges bénéficient désormais d'un système de promotion automatique leur permettant d'avancer dans leur carrière sans que le pouvoir politique intervienne pour les empêcher. Et je vous rappelle que Ben Ali surtout utilisait autrefois cette méthode, c'est-à-dire le fait de geler la carrière des juges ou les muter ailleurs comme moyen de punition pour punir les juges qui ne sont pas sages, entre guillemets, ou qui refusent les ordres qui viennent d'en haut. Malgré cela, et malgré l'amélioration de leur situation financière, les juges tunisiens restent la cible numéro 1 de la corruption. Les salaires bas et la couverture sociale pauvre ou inefficace les fragilisent encore plus. D'ailleurs, la crise du corona a démontré la précarité de leur situation. L'année dernière, après le scandale d'une juge décidée suite au refus de son hospitalisation dans une clinique privée faute d'argent, je vous rappelle que les hôpitaux ne fonctionnent plus en Tunisie, et donc, il fallait une intervention de cette sorte. Les juges, après cela, il y a eu des manifestations et les juges organisent eux-mêmes des collectes en cas de contamination de leurs collègues. Je vous donne juste à titre informatif ce que gagnent les juges. Juge premier grade gagne 4 780 dinars, l'équivalent de 1 480 €. 1 480 €. Juge deuxième grade gagne 4 080, l'équivalent de 1 246 €. Et le juge troisième grade, donc juge débutant, gagne 3 400 dinars, l'équivalent de 1 053 €. Les études le montrent, les salaires des magistrats de la Tunisie, premier pays qui a déclenché les révolutions arabes, restent le plus bas en comparaison avec tous les autres pays arabes et même plusieurs pays africains. Je termine rapidement avec la situation économique et un mot sur la corruption. Mis à part les circonstances mondiales externes qui touchent le monde entier, c'est-à-dire la crise du Covid-19 et de la guerre en Ukraine, je vous rappelle encore une fois, l'Ukraine, la Russie sont les deux pays fournisseurs de blé pour tout le monde arabe, et moi je suis presque sûre qu'il y a des émeutes et peut-être des révolutions qui seront programmées aussi, qui vont venir. L'économie tunisienne est dans ses pires états. Les raisons sont multiples, mais je voudrais juste m'arrêter sur deux problèmes: le cadre normatif de la gouvernance et la corruption, l'une des causes donc majeures quand je viens de mentionner de la révolution. L'absence d'un cadre juridique et réglementaire efficace dans lequel les entreprises publiques et privées exercent leur activité en concurrence demeure l'un des grands échecs de la transition démocratique. Selon le rapport publié le mois dernier, c'est ce rapport-là que j'ai réussi à avoir parce que j'étais récemment à Tunis. Donc, ce rapport a été publié le mois dernier, des études depuis 2019, et le gouvernement allemand a même demandé une version de cela parce que c'est quand même un document précieux pour tout contact diplomatique et économique avec la Tunisie. Donc, selon ce rapport, je cite, les entreprises publiques doivent appliquer des normes rigoureuses de transparence via la mise en place des procédures efficientes de contrôle et d'un comité d'audit. Fin de citation. Les statistiques parlent d'elles-mêmes. C'est ce que relève une autre étude analytique sur la petite corruption en Tunisie. Al-Fasad de Sarir, Tunis, ça aussi une étude indépendante qui vient de sortir et où on voit que la corruption, que le corona a augmenté ou était responsable de l'augmentation voilà, je vous montre ici, j'espère que vous allez le voir, des cas de corruption, 55%. Donc oui, il y a eu une augmentation. Le classement de la Tunisie pour la corruption, c'est comme la Colombie, la Bulgarie, l'Afrique du Sud. Donc voilà, la Tunisie est classée au même niveau. Et puis, ce qui est important, une question qui est plus corrompu, l'homme ou la femme? Eh bien, c'est catégorique. Les hommes sont plus corrompus que les femmes parce que 76% des hommes sont corrompus contre seulement 24% des femmes. Et qui commence par la corruption ou les avances pour la corruption, c'est aussi très clair, ce sont les fonctionnaires et non pas les citoyens. Donc, vous voyez combien tout le complexe normatif est au centre de véritables réformes démocratiques. Juste dernière remarque, les études démontrent que les pays les plus corrompus se situent en Afrique. Pourquoi et dans quelle mesure la dimension culturelle africaine pourrait-elle expliquer la culture de la corruption? Il y a plusieurs raisons, mais culturellement et sociologiquement, je voudrais mentionner 3 raisons. Le passé historique caractérisé par les vagues de pillage et de colonisation successives en Tunisie depuis la destruction de Carthage par Rome, donc ça commence par là, et d'une notion particulière de la richesse qui n'est pas liée à l'effort personnel, mais plutôt au gain facile. Max Weber aura certainement son mot à dire là-dedans. Deuxième raison, le régime familial prolongé dans le temps et la mentalité et qui soutient et favorise le népotisme. Troisième raison, c'est un peu rigolo, les cadeaux, c'est une tradition largement répandue, c'est une tradition populaire dans les sociétés non seulement arabes, mais aussi africaines. Ce livre était interdit sous Ben Ali, c'est un livre précieux sur la personnalité tunisienne et arabe, réalisé par un sociologue tunisien et qui justement analyse avec beaucoup plus de détails un petit peu ce que je viens de dire. J'arrive à ma conclusion. Certains font tout aujourd'hui pour minimiser l'importance des révolutions arabes d'un certain printemps. Cela n'a servi à rien. Les dictateurs sont de retour. Les islamistes sont toujours là. Et plusieurs pays occidentaux sont ravis. Ils ont repris les affaires et les contrats de vente d'armes. Tout va bien. Les peuples arabes dorment de nouveau. Mais au fond, et quant à sa configuration propre, cette nouvelle histoire révolutionnaire réévalue le rôle des sociétés civiles, diversifie les cibles de contestation en s'ouvrant aux questions de genre, de sécurité humaine et aux grands enjeux sociaux mondiaux. Tel est probablement le vrai sens de l'imagerie printanière qu'on lui associe, au-delà des souffrances vécues depuis un certain martyre d'un hiver tunisien. Le désespoir est parfois nécessaire pour bien voir la réalité du monde. C'est peut-être un microscope pour aller au-delà des écrans et ne pas tomber dans un romantisme faux. Le noir est peut-être aussi une couleur de l'espoir. Merci pour votre attention.
Merci beaucoup pour cette belle présentation. Thank you very much, Raya, for this beautiful presentation. We can talk about this later. Käte's friend told us that unfortunately Martin Olbro is not with us today, but we can continue with the presentation of Professor Greta Olson, and we will have more time to share with her and also to share together the discussion.
Excuse me, I wanted to make the abstract in English, if you allow.
Yeah, of course, of course.
The so-called Arab Spring initiated this new time of great mobilizations of revolutionary sensitivity by installing the idea of karama, dignity, at the very center of the demands made. We will find the word in France with the yellow waistcoats, gilets jaunes movement, but also in the processions that have marked the year 2019, from Santiago de Chile to Port-au-Prince, from Hong Kong to Beirut. The year 2011 thus finds its geographical replica in the year 2019, affecting this time Lebanon, but also Sudan, Algeria, Iraq, even spilling over into Iran. While it is legitimate to speak of an Arab experience of revolution, it would be wrong to speak of an Arab revolutionary model. From the Tunisian and Egyptian examples and their experiences with the exercise of power by Islamists, we can see how much the revolution is at the very center of the history and the imagination of the Arab world, both as a component of thought and as a vector of action. The first is built on a relationship with the other, made up of borrowings, fascination, and also rejection. The second lies in globalization, which has made it a privileged field marked by radical transformations, sometimes of extreme violence, the case of Syria, Yemen, Libya, etc. The lack of leadership among young revolutionaries and their disillusionment after the Islamists tried to monopolize power and impose a model of society that was far removed from revolutionary values and demands, immediately gave the spring colors of the early days a more morose trend. Moreover, the normative changes are marked by the absence of a real political will to establish a sustainable democracy oscillating between polarization and compromise. Concrete examples of the Tunisian case: freedom of conscience, Islam as a source of law, equality between men and women, independence of the judiciary, the disastrous spread of corruption, etc., testify to the failure of the normative project of the beginnings. For all that, this new revolutionary history re-evaluates the role of civil societies, diversifies the targets of contestation, and opens up to questions of gender, human security, and the major global social issues. This is probably the true meaning of the springtime imagery, associated with it beyond the suffering experienced since a certain martyrdom of a Tunisian winter in 2010. So this was the abstract that I read, and excuse me for interrupting, and please go ahead, dear Greta and Diana, and I hope it will help those who are not so familiar with the French language. Thank you.
Thank you, Werner. And we can, thank you for this abstract, and we can have a little more discussion about the Raya presentation after the Greta presentation, and we can discuss about these two examples of applying law and culture paradigm. Please, we can listen to Professor Greta Olson. Go ahead, Greta.
And thank you so much for the kind introduction. So I was playing a part earlier, critical of the law as culture paradigm. And now I want to play a more, not play, but be in a more authentic place of how grateful I am for both of the times I was in the center, and how it was, in terms of my life, really deeply changing and was a gift. And I'll begin that by saying how my own work changed through two periods of being in the center. And just because, rather than just giving you a theoretical overview, I find that it's often helpful when people tell their own stories. I'll say that during the first time, I was still a fairly new and exhausted full-time professor. I also had 3 children at home and a certain amount of turbulence at home. And it was Denkfreiräume. We can't make this compound in English, a free room for thinking. And to have the time and the leisure to interact with ideas that I did in the center was amazing. And many, not only deep intellectual things happened there, but also friendships grew up with some of the people who are on the screen today. During the second time I was there, I was going through a World War III divorce. I say that advisedly because I'd had a first comparatively very sweet little kind puppy dog of a divorce. And this one was terrible. And I was less social, more focused on my own work and sleeping, but it was equally important, this time out and time apart and bracketing over 2 years where I was. I also, to mention the center itself and the amazing infrastructure, I'll just mention Stefan Finger here. I was told by the night watchman, because I reverted to old student habits, that I was one of the first fellows that he had met, because we would see each other at 3 o'clock in the morning before I wrapped up to go home, enjoying thinking and being in the center at night by myself. So this is a history of my learning. And it went from a thinking of a singular legal culture to multiple overlapping and conflictual cultures of legality. And I'd like to say how the center made me get there, the time at the center. First, I place myself, you hear, I'm US American by origin. I've been living in Germany for more than 35 years. I have a background in philosophy, linguistics, and philological studies. And I say all that because this is a partial, or what Donna Haraway has called, which is become kind of a mantra in embodied lived feminisms. I can only pretend to present a form of situated knowledges. There is no universal we, no universal knowledge, something that Martin Ramstadt brought up earlier today. So there's no God trick here. I can only speak from the little partialness of my own knowledge paradigm and what I may say about it. Quoting Haraway from her 1988 essay, situated knowledges produce a more adequate, richer, better account of the world in order to live in it well and in critical reflexive relation to our own as well as others' practices of domination and the unequal parts of privilege and oppression that make up all positions. Important because knowledge dissemination is also a form of cultural capital and power. And as we, many of you in projects like my own, try to decolonize our own forms of knowledge and knowledge production, I believe it's important to account for our own very limited placement in fields of knowledge. So I want to give you a little histoire of learning, which made me get to two of the points that I'm making in my forthcoming book, which came out of the time at the center. This is a histoire of learning, which will also, however, be a theoretical positioning. When I came to the center for the first time in 2014 in a beautiful spring and enjoyed, and just for those of you who are there, that incredibly green place on the Rhine, all the bunny rabbits, that gorgeousness. I've often said I'll never have an office like that again. I felt like a bank director, very different from my own humble state-funded university. I came with a very different project than what my project became. It was called at that time Law's Pluralities, the Present and Multiple Futures of Law and Literature. What I was doing is I wanted to say, where has law and literature gone since its inception, its US American inception? It has various European and non-European prehistories in the 1970s movement, but most of us know it through the 1970s movement in America, which was a form of legal critique. It was very, it tended to be in its most well-known forms, propagated by people with a legal background. They tended to take a somewhat idealizing view of literature. Literature is the good, the narrative, often feminized, and it will correct law. And there was an enormous focus both on narrative literature, particularly the 19th century Victorian novel and its equivalent in the United States, a different literary history. There was an emphasis on canonical literature, the Bible, maybe if we moved outside of the Anglophone paradigm, Camus, but just barely, maybe Dostoevsky, but really concentrated on Anglophone literatures. I wanted to point out law and literature had gone multimedial. I wanted to point out literature is not the locus of the moral and the good, and all the different ways it was being done. I was doing this on the one sense by comparing medial interactions with law, also fictional ones. These are two images. I find television dates itself rapidly, but you'll probably know Judge Judy. The show just ended. She was on for more than 20 years. It was a pseudo-reality judge show in which Judge Judy, in a real neoliberal fashion, there was a pre-agreement that what she said in the small claims court would be valid, would blame and shame her contestants. Shame on you, triple shame on you. And there was a lot of Schadenfreude involved. A copycat version, Barbara Salisch's in Germany, Richterin Barbara Salisch, which became shortly after Judge Judy occurred, also a real family judge from Hamburg, who then went on to a fictional show and had a completely different manner. It was, of course, a German law classroom, but here Judge Salisch explained law, asked the correct questions to reveal the real culprit, and did what I see as a basis of a legal formation in which there is more trust in the legal system, did a lot of explaining and distributive justice. So I wanted to show the differences of how these kind of come out of their cultural formations and go back to it and influence. I wanted to get away from an idea that Lex Entertainment, Lawrence Friedman, that all forms of medial interactions with law are distortions. Well, my project did not say that. What happened to me in that beautiful center, and I closed my eyes and imagined both of the offices I had there, and just as important for me, I would run in the morning, take a shower there, and then begin to work, was interacting with the fellows. This was particularly the case during that first period. I became a student again, and I became so much more interested in the work of those around me because I had the leisure to read, and not in that kind of efficiency mode I often have in my life as a professor. How quickly can I take this in and apply it to whatever it is I need to deliver 5 minutes ago? But to think about what others were saying. I am so happy to see Martin Ramstadt here today. He was working on an entry on legal pluralism and differentiating forms of legal pluralism in legal anthropology and other forms of legal pluralism. Through Martin, I became aware of Sally Falk Moore. I started to read Paul Berman. I started to read De Sousa Santos, all of whom centrally impacted upon what my book became, that law and literature, in the way I understand it, is an intervention into a legal environment that is legally pluralistic. This was huge for me. I also learned more about the legal consciousness movement. At the time, Pamela Feldman-Savelsberg was working on a project about how women from Cameroon were interacting with legal institutions in Germany, particularly in Berlin, and telling each other stories, creating communities so that they could figure out how to make this legal system work. I became more consciously aware of the legal consciousness movement, but this led me then to think about other notions of legal subjectivity, also German language ones that had happened long before. This led me to Schering, to Ehrlich, and also Jakob Grimm. Importantly, I noticed in the legal consciousness movement that there was a tendency to focus only on narrative and not other kinds of approaches to law. And I'm thinking of Sylvia and Avik here in Law Stories, but also to talk about interactions with law as with state-centered law and not other kinds of normativities. In a remark in one of her essays, Raja made me think more, and you see this is a sequential thing about subjective and effective relationships to constitutions. And through a remark she had made in one of her writings, I started to think about it. Why is that? And there were other peoples working on constitutional formations. Why is that people have a relationship to their constitution, particularly the preamble, that they do to foods or to languages that they associate with their local cultures, and will passionately defend those, also in very effective terms. I also, and this was some pushback I was giving to the Recht als Kultur paradigm, I also interacted, because I'd had no formal training in Rechtssoziologie, legal sociology, with the grand narratives. And I was introduced by Christoph Sundtrap, Daniel Witte, Werner Gebhardt, also Hans Vorländer, to the work of Foucault, Bourdieu, Luhmann, Habermas, on thinking about how legal field systems interact with other forms of human activity. As I mentioned earlier today, that all seemed much too Hegelian, totalitarian, we can describe everything, but I thought, this is really interesting, a grand narrative about validity cultures. It challenged my notion and that partial notion of what we can and cannot say from a critical cultural studies perspective. I was also, however, interested in how were people at the center also working on pragmatic cases. And I mentioned today Nina Detlef's very culturally sensitive notions of clashes going on, particularly in queer marriages and forms of adoption, and how this is being negotiated throughout Europe in terms of law. There are many, many others that I will not mention here that have also influenced my work. So where did this all go? This going back to being a student again, I once described it to someone visiting the center as a boarding school for adults, where we got to learn and enjoy spending time with each other. It led to a very different project. This was supposed to come out in June. I think it will be a little bit later. The book is now From Law and Literature to Legality, in fact, with Oxford University Press. How was this book? What's the direct relationship? And I'm only mentioning two moments. One, a notion of law as one thing moved to a messy and explosive concept of legality, as I use it in the book. Let me explain this very briefly. Law, to be thought of as legality, is not meant here in its more typical usage as something that is allowed for or demanded by law or conforms to a legal framework. I do not mean Kelson's conformity to the legal rule or the control by rules that Hart names as regulating to the requirements of justice. By contrast, I use legality in an inclusive sense that goes far beyond an allegiance to state-made ordinances and laws in two different ways. First, the first way is legality compromises the totality of what people perceive to be binding norms. And that includes also state-centered and enforced law. Legality includes, however, also individuals and groups' Rechtsgefühle, that is, their impassioned feelings about their legal environments, as expressed by protesters, for instance, in Berlin, who equated coronavirus-related health restrictions with fascism. Legality is then whatever people believe to be lawful or full of law. This notion of legality takes in a pluralistic understanding of law, which includes what Eugen Ehrlich termed Lebensrecht, living law, or the codes of behavior and rules for ordering conflicts that proceed and extend beyond law on the books. In the second case, legality as I use it denotes all expressions of the legal, that explosive star sign, such as those in images and sculptures relating to law, also in ordinances and legal judgments and legal institutions, as well as in courtrooms and monuments. Law is disseminated in sounds and images, as well as in legal texts, also in narratives and metaphors and performances, and this includes fictional expressions of law. Expressions of law as legality have traditionally been inscribed in stone or words or images, yet they can also be found in instances of what my book calls popular legality, as in legal television or in online communities and their discussions of legal political events and effects. So before you push back, this is all too vague, something that Werner said about Ehrlich's Recht earlier today, I see law, let me frame this a little more, as a cultural political process that is made sense of and disseminated through contextually specific. Martin spoke earlier about the local and the contextual, specific performances, narratives, topoi, images, and affects. Law is also, however, an extraordinarily specialized discipline, and this is where the fictional comes in, and a set of variegated practices whose rules and procedures vary depending on the legal system in which it takes place, the different types of law practiced within an individual system. I'll name only as some local ones: intellectual law, property law, labor law, family law, immigration law, bankruptcy law, public law, European law, and even the court or local jurisdiction in which the given type of law takes place. As you look at given courts, you'll see in overlapping legal systems that they have an ethos and a manner to themselves. I want to argue that due to people's varying placements within their legal environments, and this includes also legal actors, and due to law's extremely high level of specialization and legal actors' daunting degree of professionalization, the great majority of individuals have access to law and legal processes via popular regality. Information about what people think of as law is disseminated through popular media texts, through exchanges in social media, what Cassandra Sharp calls hashtag jurisprudence, that's where legal ideas are being worked out by lay people, via journalistic reports on spectacular criminal or libel trials, or through television law. So when I think about what most people from my own culture of origin think of when they think of law right now, they think about Johnny Depp versus Amber Heard, or maybe they think about Roe versus Wade about to be overthrown in the United States and the consequences of that. If you're coming from a German cultural paradigm, and a collaborator of mine, Laura Borchert, was kind enough to help me think about this, what will you be thinking about when you think about law? Till a couple of weeks ago, it would have been the various restrictions and also new legislation on do we or do we not have to be vaccinated or wear masks, in what context. Since the war began 11 weeks ago, it's now about, for instance, will the budget of the Bundestag be raised to a huge amount as compared in the past to support German support of the Ukrainian effort. Because most of us are not legal actors, I would argue that how we interact with law is highly fictionalized and incredibly multimodal. Also, second point, as a cultural theorist and somebody who grew up in critical cultural theory, the idea of a legal culture is highly problematic. My experience, I've lived in Germany, as I've mentioned, for 30 years, is incredibly different as, although I'm not a German citizen, I'm a civil servant on a high level. I have, through my whiteness, through my tenure, through my earning a fairly good wage, I have a level of security and also probably faith in my German legal environment, which is entirely different than someone who is seeking asylum right now. And particularly if that person is not Ukrainian or not white. So legal cultures are not one thing. To say a legal culture is to perpetuate a center periphery kind of thinking. We are the center of knowledge. We can look at the object. We want to get away with it, and suggest that a culture is one thing or doesn't change. Rather than a legal culture, I would say we have overlapping, contiguous, and always conflictual cultures of legality, as I've described previously what I meant by legality. So I'm not, and this is a critique of Ehrlich, and a pushback against it by someone who I believe has done a lot to make us rethink ehrlich's importance in Europe, Mark Hartog, is I'm not trying to define what law is. Rather, I'm thinking about how do people interact with law. Within this, I recognize moments of increased actual legal hybridity, as in what Gunther Teubner, someone I also had the privilege of meeting through the center, has called global Bukowina, or the present caused by Lex Mercatoria, or in the many localities where colonial law has been dismantled or exists contiguously with indigenous legal practices. With Ehrlich and others after him, I'm pointing out that there are forms of legality, that is, expressions of law in the largest sense, to which people feel more effectively drawn than to state-enforced law. Individuals and communities' Rechtsgefühle, their passionate feelings about law and justice, cause them to identify with alternative legalities more than with the law that currently binds their behavior. Cultures of legality, then, need to be understood in the plural rather than as isolated, monolithic legal cultures. A variety of overlapping positions exist within a dynamic and historically contingent legal environment. A broader understanding of legality helps to account for people's different positions within their legal environments based on whether they agree with that environment's dominant messages and forms of interaction, are resistant to those dominant forms, or negotiate with them. Legality takes in people's Rechtsgefühle, their impassioned feelings about law, their legal subjectivities. Very briefly, Rechtsgefühle, allow me to give you two, in shorthand, two expressions of Rechtsgefühle. On the left, we see a demonstrator holding up the first articles of the Grundgesetz, the German constitution, the basic law, protesting against Corona restrictions. On the right, for me, an effectively even more disturbing image, quoting all kinds of constitutional imagery and symbols. These are the mob that stormed the US Capitol on the 6th of January last year. Now, I want to point out, and this is work I'm doing now, there are many different definitions of Rechtsgefühle. If we have time, I can come back to them. It can be an internal critique of law, of what's appropriate, or it can be, and I think Gießen was getting at this, a form of political energy, or it can be, Andreas Fischer-Locano, a call on a different kind of legal reform, a legal revolution based on what he calls a Rechtsgefühlkultur, a culture of legal feeling. So, Daniel, Werner, Christoph, everyone else, here's my grand récit. I got there, and it was through the education I received. I had to put all that complexity together and make it sense to me, and this is my imperfect attempt to do so. Rather than law, legality, what people think of as law, is negotiated through Rechtsgefühle with groups and also persons who have variegated expressions, and legality is expressed both through what are traditionally thought of as legal texts, ordinances, decisions, processes, institutions, but also through forms of fictionality, narrative, visual, and media expressions of law. But the journey didn't stop there. I say with deep gratitude, I continue to learn through the center. And it is for me with a great feeling of personal sadness that you are ending, because I've found it always renewing to come back, to be able to speak with fellows now, to interact, because I continue to learn. So long after I left the center, through a workshop you did on the first Corona Normativities volume, I got in contact with Judith Hahn, who commented on my presentation there, and her description, because I was talking about the dominant narrative of the pandemic was it's been terrible for women, it's been terrible for anyone, for care workers, and it's been terrible for queer and trans communities. How do we not internalize that? What other forms could there be? And Judith mentioned in an email to me and Nina Detlef, how nuns had during the pandemic, because they had no choice, performed mass with themselves, and how this was a new form of religious celebration that occurred. This affects work on forms of queer and feminist resistance and resilience that I'm doing now. Sanya, who I had, Bujanovic, who I had the pleasure of knowing both in my first and the second stay, and I continue to converse about feminist themes. She edited an issue on feminist responses to populist politics, to which I wrote the foreword in a journal I edit, and her work has contributed to work I'm doing now on towards decolonial trans feminist women exim. That is, very briefly, the impossibility of doing feminism now because it's inscribed as white supremacist, as bourgeoisie, and as transphobic, and that nonetheless we have to do it. So how do we do that? What critical position do we take on? I thank you for that learning. And it goes on in a major research project I'm doing with others, with lawyers and sociologists at the University of Gießen and the University of Marburg, Menschenrechtsdiskurse in Migrationsgesellschaft. I'm working on Rechtsgefühle and images of migration. And very briefly, I developed a typology for the so-called crisis of the 2015 and 2016 crisis, in which refugees, I won't do a whole analysis for reasons of times, but the image on the left, which was very typical, were dehumanized, were treated as natural threats, and body politic, the white middle-aged bourgeois couple seen as literally like a tidal wave, but also a huge mouth as engulfing and destroying Europe. As wonderful as our German response has been to welcoming our homes to migrants from the Ukrainian war and the invasion of Russia, there's also, and I won't be the first to say it, a great deal of racism in how these images of migration are being depicted now. And I could show you 100 images like the one on the right, and you see a very resolute woman looking not off at the camera, ready to begin her life, also bourgeois, middle class, like the viewer of the image, primarily also white. And I suggest she recurs to heroic notions of migration that we had in Europe after World War II. Further, and this is my final slide. I mentioned this morning that also in a book edited by Peter Goodrich and others, that I've been working on comparing anti-trans legislation in Germany and the United States with Laura Borchert, a colleague and collaborator of mine. And there's a utopian promise of there, what transing identity, also legal identity, could do. But I also want to bring this back to something I wrote in 2018, and this was commenting on Werner Geppert's, one of his multiple identities, he has many, as an artist, and on one of his images. And this is a different view of that now. Commenting on the image of Werner, an avatar of him in a garden of knowledge. The utopian project of queering entails not only deconstructing the policing of how we are made to behave in binaric fashion as women, a problematic term, hence because it's so overinscribed, and men, it also challenges the straitjackets regarding how we are allowed to create. With his breakout spirit and excessively energetic forms of creation and creativity, Werner Geppert queers in the sense that he upsets and undoes the formalities of German academia, our high level of professionalization and differentiation. He pushes the limits of much wider system that awards only narrowly prescribed forms of excellence with a jealously doled out currency for recognized forms of achievement. So it was with Werner, as the center came into being, that over the board, excessive, queering all over the place energy that brought us all together, both in that beautiful colleague and also here today. And I thank you for that. I've often had to give you pushback on that, on various parts of it, because it takes a lot of space. My main issue today was, what was I going to wear? Because as we know, Werner is a sartorial genius, and that is something we all need to think about a lot. But I want to thank you, Werner. I want to thank Nina. I want to thank Clemens Albrecht. I want to thank Raja Sakrani as the beginning of the center and carrying it on. With this, I gave you one once before. I can only give it to you virtually now with a paintbrush, because of your encouraging us, all who are here and all in the center, all who had the freedom to express ourselves in all sorts of messy ways, to be creative and to go beyond what we had known. Thank you.
Thank you very much, Greta Olson. It's really hard to conclude to these two beautiful presentations.
Can I do a question, Diana?
Yeah, you go ahead.
Okay, so one question to dear Greta. Of course, I feel very much honored to become a part of the queer community that I didn't know before. Though I'm a fan of RuPaul and of other elements in that scenery. But to do it by way of bridging disciplines and queering the going beyond of disciplines is a very nice and wonderful image, and I thank you very much for that. I have one question to your talk, and that is simply, and don't take it wrong, but how would you translate legality? That is my question. And if you find a translation into German that does not hurt all the feelings that we have about the idea of Legalität, to instill into that notion what you have done, the whole bunch of cultural, artificial and artifacts and emotions and the senses and everything of this kind. This is against, in German, I would say. I can't say it for English because I don't understand this crazy and much too difficult language. But in German, it would be against the popular and normal understanding of the word legality. Of course, any kind of definition is allowed. The question would only be, will you really make a career with that, a word career, so to say, with this kind of wording? That's my question to you. And the question to Raja had been very shortly, I'm still wondering about this kind of ambiguity in learning processes after the so-called Arab Spring, and some pushes back even before the time of the revolution to Ben Ali, and even much before then going to traditional concepts of, so to say, an Islamically impregnated society. Is it the fact of external factors or more of the internal traditions and structures of Tunisian society? That would be a kind of question I have, and a lot of others, but I will stick to those, to this one. Thank you very much for your attention.
Thank you for the pushback, my dear. It's always a question when you start a new concept. And as we know, or when you redefine a word, legality, which would be Rechtsmäßigkeit of Deutsch, is already multiply inscribed and means closeness to the what would be called the letter of the law. I think to get to it in a more, I was inspired by Sylvie and Avik and legal consciousness, and it seems to me to be inclusive. Legality is, of course, much nicer in our German context. To be open to a reinterpretation of the expressiveness, which takes in both that narrow, what Lawrence Friedman would call internal legal culture, institution, legal text, decisions, statutes, but also all of the, and this is the point I want to make, we don't need to define law, but effectively people deal with law as whatever they think law is. So if they're duking it out on Twitter, or all the stuff that's being projected at Amber Heard right now everywhere, that is a form, I believe, also of people interacting with what they think law is. And it's trying to put a name on it, and it has to stay in the law domain, the connotation of the domain, and it also has to be more expensive. And I'm passing the baton to dear, lovely Raja.
Okay, thank you.
Thank you, dear Greta. Well, Werner, to shortly, it is of course a very complicated question, and you know more than others perhaps that I am intensively working on the question of ambiguity and paradox or paradoxes in Islamic legal cultures since some months now. So you mentioned external factors or internal factors, in fact, both. But basically, the big problem, I think, as I mentioned in my paper, we have a very typical cultural background for Arab societies, but this background is really huge, rich, with a lot of paradoxes, with a lot of schools of ideologies, of political movements. And it was, of course, not easy after the revolution to work on this. Oh, we need centuries, perhaps less than this, but this work has to be done by Muslims themselves. It's not the case. So we have this internal problem. And we have, on the other hand, an external one, which is linked to the history of those regions. A lot of, since the first centuries of Islam, conquests, and then with the Ottoman Empire was also a kind of colonial empire, then the European colonialism, then even the experiences after the Second World War and colonialism with Arab nationalism, as I mentioned, with communism also, which was very present in countries like Syria, like Iraq, like in Tunisia also, but less important, in Algeria. So all this was as background, very problematic background to work with, and of course the other factor, as I said, is the revolution or revolutionists in those countries were led especially by young activists. And the lack of leadership among them, the lack of a very clear program to translate the values and aims of those revolutions, of course, was like present for Islamists, who are really very good organized people with a lot of money, as I said. And that's why the first experiences, at least as we saw in Tunisia and Egypt with Islamists, led to what we know now. So a military regime in Egypt, in Tunisia, fortunately, it was better, but the situation is very, very difficult. So I would say, to respond to your question, we have both external and internal factors. And when we come to the question of normativity, you know that even even in the Quran or Sunnah, or you have always paradoxes. You have a thing, a response, and exactly its opposite to everyday life, to the political problem, to juristic norms, and this situation is really, it's like, I would say, a kind of schizophrenia somehow. And of course, it's not easy to come with a new, a modern, democratic, normative project in these conditions.
Thank you.
Thank you,
I see your point. Thank you very much.
We have two other questions. One from Angela Condero and Martin Ramstedt. Angela, maybe you want to go ahead with your question.
Yes, thank you. It's a really brief question to my friend Greta. Why? Well, I skip all the things that I will say later about how great the presentation was and how interesting the current research and current book are also for my work, from my perspective. I had a doubt about your use of legality instead of normativity. So this shift from law to legality, which I can understand because it's a shift from a subject to the whole semantic field related to that subject. But in some sense, even the fact that you said that in German it would be Rechtsmäßigkeit, so the substantivized version of Recht, which translates law, lex, perhaps use would be in Latin, and not the nomos, which is the root for the concept of normativity, which is a broader concept. I'm asking this because in your definition of legality, I think you underlined aspects of informality, of inclusivity, openness, as compared to the formalized law. And so the idea of normativity, normativity, perhaps would include even more than mere legality. I'm sure that you have a reason for it. I'm just curious about it. Thank you.
First of all, Angela, it's amazing to see you. It's been a long time. We were almost roommates and spent a lot of time together during my first day, and did a lot of processing of every kind. And Angela's work on exemplarity is one of the things I couldn't mention today. Thank you for asking that. I, of course, thought about normative orders or normativity, because we also, this was mentioned in conjunction with Raja's work, we have a huge center for that in nearby Frankfurt, normativen Ordnungen. It is normativity, but I think when I came to the center, and we were one of the first workshops I met you, and people were talking about dimensions of law, I had this real, well, that's not law. Fashion, that's not law. Ritual, what are they talking about? And then I started to think more about legal pluralism seriously, not also from anthropological, but really what I think Ehrlich was doing was saying, we have a very good ordering system here that Austrian-Hungarian law is now imposing upon state-made law. And that was a process, and De Souza Santos of excluding other forms of ordering and conflict resolution. I think that's important, but I think it goes beyond normativity, because what I'm also getting at is that messy affect. The horrible alternative for Germany advertises sometimes in the little town where I live. And before the big vote in 2019, In Europe, they were advertising freedom, oh, I'm translating, instead of Brussels. And I'm not sure that that's normativity. It's this kind of visceral, this is my language, this is my imagined community, this is my food, it's mine. It's an exclusionary gesture that I'm not even sure is always about normativity. So that's a very short answer. Thank you.
Thank you, Greta. Thank you, Angela. Martin, do you have another question? And maybe after that we can close the panel. Go ahead, Martin, please.
Thank you, Diana. I want to address both of the speakers. Thank you very much for both of your presentations. Raja, I'm really looking forward to your book. I don't have a question really, apart from perhaps from a comment which stems from my reading of Lawrence Rosen's book on Islamic law, where I particularly remember that he emphasized that let's say in conflict resolution, in traditional Islamic conflict resolution, and I think his context was North African, was that there was no real punishment, but rather harmonization of different views. So what you said about the tensions and the paradoxes, with modern notions, Western notions of law, where everything has to be rationally fitting. What is perhaps lacking is the more traditional approach to balancing differences in such a way that everybody keeps face, or can keep face, and can come to a good compromise. But in any case, I wanted to thank you that I'm very proud that you were teaching the course on Islamic law and its accommodation in different European legal cultures, and that you are going to do so again next year, because the students were fascinated, particularly because it made so clear what legal pluralism or normative pluralism today is. So I hope that you write your book soon and I can read it. Thank you very much.
I hope too. We will see. Look, thank you very much, Martin. To answer, I would like to make a difference, first of all, between the judicial system in Islam, I mean, from the birth or 2 centuries, let's say, after the birth of Islam, until perhaps the period of colonization in North Africa, but also elsewhere, and the normative and texts, normative texts. It's, you know, I'm very critical with this, which means basically Quran and what we call Sunnah, this huge, we have thousands and thousands of hadith, which constitute the Sunnah. One of the big, at least in my eyes, and I'm not alone in this, in Islam is this sometimes a huge gap between theory and praxis. So what you mentioned, it's true. We had in Islam really very nice experiences of this flexible justice which is looking not for the punishment, but how to manage conflict, how to find solutions to social conflict, how to manage the question of risk, for example. And in this, Islam was really a very modern system, I would say. You know, but when we talk about the texts, the sacred texts, then we will have problem, because then we are in a completely different other logic, especially when you look at the discourses of Islamists nowadays, or Salafists, or really these radical tendencies. There is a kind of sacralization of those texts. So we have to apply them as they are, without any interpretation, without any reflection. And this is even completely in antagonist to this old tradition. So you see here, I cannot talk about paradoxes in the judicial system itself, but I would say there is a paradox between texts, between theory and the praxis. You have texts sometimes which are very, very rigid one, but when you look at praxis, you will have judges who are really trying to find solution in a very flexible way. So as you have two words, you know, and that's why I said before, we are even dealing with a kind of schizophrenia, and we have really to go ahead and to go out of this Teufelkreis, so to say. You see, this is what just I can say here, very, but of course the thing is more complex, and we can discuss more about this. But just I wanted to make this difference, to make it clear, because for many, when we talk about Islamic law, we think as in our Occidental tradition, on texts, on codes, and so on. No, in Islam is different. And of course, we don't have this binary code, for example, valid, invalid. We have really a big palette of judicial qualification of contracts, of kind of punishment, punishment, as I said, which are basically in the sense of social regulation of conflicts and of how to and managing risks, for example, and justice, the notion of justice between individual interests and the interests of the community, for example. So you have all this. It is, you know, somehow Islamic law, if we will summarize all this, is a mixture between case law and continental law somehow, you know, and that's why we have this kind of very, very complicated tension and paradoxes also sometimes.
Thank you very much, Raja.
You are welcome.
Thank you, Raya.
And I have a comment to or not a comment, a question to Greta, which I really enjoyed. Thank you very much. I was very much struck by the importance effects have in your model. I was wondering, they don't arise from nowhere, and they are apt to change according to very concrete experiences. I was wondering where do you locate these experiences? And I was also, I mean, I was not trying to translate legality, so I wasn't bothered by this. I was just wondering what's the relationship, or could one call legality also, or what's the relationship between legality, let's say, and culturally embedded justice? Because for me, this culturally embedded justice is also rooted in effects and aesthetics. Thank you very much. Thank you very, very much, both of you.
I think of affects can arise from different places. They can arise from, and this was where Pamela was working, also where Sylvia and Avik are working, that in a cohorts group, for instance, to be African American in the United States is to have a completely different, as a cohort, particularly if you are gendered as male, different relationship to law than if you are perceived as white and as a white woman. So that would be the group. And then there's the individual affective response, and then things change. Depending on your group and your individual dealings, not only with real legal processes, and this is where I questioned Sylvia and Avik's model, but also with imagined law, whatever you're getting through your Instagram feed or your TikTok feed, and also what you're discussing, or, as I said, spectacularly mediatized cases. Then, and my only concern about your culturally embedded justice is it sounds great. Like, I think the arts of Black Lives Matter, they're a form of legal pluralism to say the legal environment in which we live is unjust. But in my book, I also take a horrible neo-Nazi right-wing song called Im Namen des Gesetzes, which is obviously quoting German law and German court procedure in order to say, as my grandfather would say, we're going to hell with the orchestra, and we need a new law of the German people that's really in Namen des Volkes. And there we'd have to question, what do you mean justice? It can be an expression, often an expression of dissatisfaction with the existing legal order. Thanks so much, Diana. Thank you for your patience.
Thank you, everyone. Thank you, Raya and Greta. And sorry for this. We have running late, but we can see with these two beautiful presentation, like the example of the great example of accomplished promise of the law and culture paradigm. And it's like an invitation to all of us to follow this way for the future and the perspective of this paradigm today. So I'm really, really happy to share with you this panel. And thank you, Raya. Thank you, Greta, for this beautiful presentation to show us the resilience of law, legality, or mostly the resilience of the actor of law. Thank you.